Over 70,000 people were referred for potential deportation in the UK in recent years, and under the new 2026 deportation law, that number could rise even higher. But here's the part most people don't realize. It's not just serious criminals who could be affected. Some long-term residents, visa holders, and even people who have lived in the UK for decades may now face tougher scrutiny. The rules are changing, and quietly, they're changing fast. So what exactly is happening? Who is really at risk? And could someone who believes they are completely safe suddenly find themselves facing removal? The government says the changes are about national security, border control, and restoring public confidence. Critics argue the impact could reach much further than expected. In this video, we'll break down exactly who's affected, who isn't, and what you should do right now. Because when it comes to immigration law, what you don't know can hurt you. Number 1. What exactly is the new 2026 deportation law? The 2026 deportation law isn't just a minor policy tweak. It represents a significant shift in how the UK approaches immigration enforcement. At its core, the law aims to make deportations faster, broader, and harder to challenge. While previous rules focused mainly on serious criminal offenses, the new framework expands the scope of who can face removal and reduces the time available for appeals in certain cases. In simple terms, the system is becoming stricter and more streamlined. So why now? Over the past few years, the UK has faced rising pressure around border control, asylum backlogs, and illegal migration crossings. Public debate has intensified, especially around small boat arrivals and overstayed visas. The government argues that tougher deportation powers will act as a deterrent, reduce strain on public services, and reinforce national security. Supporters say it restores fairness to the immigration system. However, critics warn that speeding up deportation could increase the risk of mistakes, especially in complex cases involving long-term residents or people with family ties in the UK. Immigration law is rarely black and white. It's layered, technical, and deeply personal. And here's the key difference in 2026. Enforcement is becoming more automated and data-driven. Government departments now share information more efficiently, making it harder for visa overstays or documentation gaps to go unnoticed. This isn't just about headlines. It's about how rules on paper translate into real-life consequences for thousands of people. The question is, where do you stand under these new rules? Number 2. Who is most at risk under the 2026 deportation rules? Now let's talk about the part that really matters. Who could actually be affected? Because this is where the surprises begin. First, foreign nationals with criminal convictions remain at the top of the list. But under the 2026 changes, the threshold for automatic deportation may be lower, meaning shorter prison sentences could now trigger removal proceedings. In the past, deportation was typically linked to more serious offenses. Now, repeat minor offenses or sentences that previously might not have crossed a line could carry much heavier immigration consequences. For someone who has built a life in the UK, a job, a family, children in school, that shift can be life-changing. Second, visa overstayers and individuals with unresolved immigration paperwork are facing closer scrutiny. With increased data sharing between government departments, gaps in visa renewals, expired permits, or administrative mistakes are easier to detect. Some people may not even realize they are technically non-compliant until they receive official notice. Third, certain asylum seekers and irregular arrivals may experience faster processing and reduced appeal timelines. The government frames this as efficiency and deterrence. Critics worry that speed could sometimes come at the expense of thorough review. What makes this law powerful isn't just who it targets, it's how quickly action can now happen. Deportation processes that once took years could move much faster. So ask yourself, is your immigration status fully secure, or are there small details you've been meaning to check? Number 3. The hidden category. Here's something many people don't realize. Living in the UK for 10, 20, even 30 years does not automatically protect you from deportation. If you are not officially a British citizen, your right to stay depends entirely on your immigration status, and under the 2026 changes, that distinction matters more than ever. Many long-term residents hold indefinite leave to remain ILR. It sounds permanent. It feels secure. But legally, it is still conditional. ILR can be revoked in certain circumstances, especially if someone faces criminal issues or extended absences from the UK. Citizenship, on the other hand, provides a much stronger layer of protection. The two are often confused, and that misunderstanding can create serious risk. Imagine someone who moved to the UK as a child, grew up here, built a career, raised a family, but never applied for citizenship because they felt British anyway. Under tighter enforcement and expanded deportation powers, that assumption could be dangerous. The law does not operate on feelings. It operates on documentation. Another issue, some residents delay naturalization due to costs, paperwork complexity, or simply putting it off for later. But later can arrive unexpectedly when policies shift. The key takeaway is simple. Permanent residence is not the same as permanent security. If you're eligible for citizenship, it may be worth seriously considering it now, not when rules become even stricter. So ask yourself honestly, if the rules change tomorrow, would your status hold firm? Number 4. Faster appeals. Less time. One of the most powerful and potentially controversial parts of the 2026 deportation changes isn't just who can be removed. It's how fast it can happen. In previous years, deportation cases could stretch on for months or even years. Appeals, human rights claims, administrative reviews, the system moved slowly. For many people, that time meant everything. It allowed them to gather documents, seek legal advice, prove family ties, or challenge errors. But under the new framework, the focus is on accelerated processing. That means shorter deadlines to respond, tighter appeal windows, and quicker decisions. On paper, speed sounds efficient. The government argues it reduces backlog, saves taxpayer money, and prevents long periods of uncertainty. But here's the reality. Immigration law is complex. Missing a single deadline, even by days, can drastically affect the outcome of a case. And when timelines shrink, pressure rises. Imagine receiving an official letter and having only a limited window to respond. Would you know exactly what documents to gather? Who to contact? What forms to complete? For someone unfamiliar with the legal system, that urgency can feel overwhelming. Another major change is improved digital monitoring and interdepartmental data sharing. That means cases may move forward automatically once certain triggers are activated, with less room for delay. The bottom line? Speed increases consequences. If you are unsure about your immigration position, waiting is no longer a safe strategy. Preparation is. Because in 2026, it's not just about whether you qualify to stay. It's about whether you can respond in time. Number 5. What you should do right now to protect yourself. At this point, you might be wondering, okay, but what can I actually do? The good news is this. While laws may tighten, being informed and prepared give you power. First, review your current immigration status carefully. Don't rely on memory. Check your visa expiry date, your residency documents, and any pending applications. Even a small administrative mistake, like an expired biometric card or missed email from the Home Office, can create unnecessary risk. Set reminders. Keep digital and physical copies of everything. Second, if you have indefinite leave to remain, confirm you meet the residency requirements and haven't spent extended periods outside the UK that could affect your status. If you're eligible for citizenship, consider whether now is the right time to apply. Waiting might feel convenient, but policy changes rarely move in a more relaxed direction. Third, if you have any past legal issues, even minor ones, speak to a qualified immigration advisor. Don't assume something is too small to matter. Under stricter enforcement, patterns and repeat issues can carry more weight than before. Fourth, stay alert to official updates. Immigration rules evolve quickly, and misinformation spreads even faster. Rely only on trusted legal sources. Most importantly, don't panic, but don't ignore the situation either. The worst position to be in is unprepared, because in times of tighter enforcement, clarity, documentation, and timing are everything. And the smartest move you can make in 2026 is making sure your status is secure today. Number 6. The bigger picture. Whenever a major deportation law is introduced, the official explanation usually centers on national security, public safety, and border control. And to be fair, every government has a responsibility to manage immigration effectively. Supporters of the 2026 changes argue that stricter enforcement restores fairness, especially for those who follow the rules and wait patiently for legal entry. But here's where things become more complex. Immigration policy doesn't exist in isolation. It often rises to the top of the political agenda during times of economic pressure, housing shortages, or election cycles. Public opinion can shift quickly, especially when migration numbers dominate headlines. In that environment, stronger deportation powers can send a powerful political message: control, authority, action. Critics argue that while enforcement is necessary, overly broad deportation powers can create fear within lawful migrant communities. Families may feel uncertain. Long-term residents may feel targeted. Employers may worry about workforce stability. The emotional impact of policy changes can sometimes reach further than the legal wording itself. There's also the economic angle. Migrants contribute significantly to sectors like healthcare, construction, hospitality, and technology. Stricter deportation rules may protect certain priorities, but they can also reshape labor markets in unexpected ways. So the real question isn't just who can be deported. It's bigger than that. It's about balance between security and compassion, enforcement and fairness, political messaging and human impact. And depending on where you stand, this law might feel like protection or pressure. Number 7. Final reality check. By now, one thing should be clear: the 2026 deportation changes are not just about headlines or political speeches. They are about real people, real paperwork, and real deadlines. And the biggest mistake anyone can make right now is assuming this doesn't apply to me. Many people only look into their immigration status when there's already a problem: a rejected application, a warning letter, a missed renewal date. But under tighter enforcement and faster processing systems, waiting until something goes wrong could leave very little room to fix it. Ask yourself honestly, do you know the exact expiry date on your visa? Are you 100% sure your documentation is complete and up to date? If you received an official notice tomorrow, would you know what to do first? These aren't fear-based questions. They are practical ones. Because the truth is, immigration systems are becoming more digital, more connected, and less forgiving of delays. Small oversights that once slipped through unnoticed may now trigger immediate action. At the same time, being proactive puts you in control. Checking your status, seeking advice early, and understanding your rights can dramatically reduce risk. Information is not just awareness, it's protection. So whether you're a long-term resident, a student, a worker, or someone planning to move to the UK, this is your reminder: don't leave your future to assumptions. Because in 2026, preparation won't just be smart, it may be essential. Number 8. What happens next? So where does all of this lead? The 2026 deportation law may not be the final chapter. It could be the beginning of a broader transformation in how the UK manages immigration. Policies rarely stay static. Once enforcement systems become faster, more digital, and more interconnected, future governments can build on that foundation. That means today's strict update could become tomorrow's standard practice. We're already seeing a shift toward automation, biometric tracking, and cross-department data sharing. In the future, immigration compliance may feel less like paperwork and more like continuous monitoring. For some, that creates reassurance. For others, it raises concerns about privacy and fairness. Either way, it signals a move toward a system that is more controlled, more efficient, and potentially less flexible. Another key question is how courts respond. Legal challenges often shape how far deportation powers can go. Human rights arguments, family life protections, and proportionality tests could influence how strictly the rules are applied in real-world cases. And let's not forget public opinion. Immigration policy is deeply influenced by social mood, economic conditions, and political leadership. A change in government could adjust priorities, tightening further or softening certain areas. The takeaway? Immigration in the UK is entering a period of sharper enforcement and closer oversight. Whether that trend continues depends on politics, courts, and public reaction. But one thing is certain: staying informed will matter more than ever. Because the future of immigration won't just be written in Parliament. It will affect homes, careers, and families across the country. Number 9. Key takeaways. After breaking down all the details, it's time to step back and focus on what really matters. Practical steps you can take to protect yourself and your family. The 2026 deportation law may seem overwhelming, but knowledge and preparation are your best tools. First, know your immigration status inside out. Whether you're on a visa, hold indefinite leave to remain, or are considering citizenship, understanding your legal position is critical. Small mistakes or outdated documents can trigger serious consequences under the new system. Always double-check expiry dates. Keep copies of important documents and track correspondence from the Home Office. Second, don't wait for a crisis to act. If you're eligible for citizenship, consider applying now rather than later. If you have minor past legal issues, speak to a licensed immigration advisor early. The 2026 law accelerates deportation timelines, so proactive steps can make a huge difference. Third, stay informed about updates. Immigration law evolves quickly. Trusted sources, official government announcements, and accredited advisors are essential to understanding what changes might affect you next. Relying on rumors or social media alone can put you at risk. Finally, prepare emotionally and financially. Changes in immigration law can create stress, uncertainty, and unexpected costs. Planning ahead reduces anxiety and ensures you're ready for any situation. In short, the law is strict, but it doesn't have to catch you off guard. With preparation, vigilance, and expert advice, you can navigate these changes safely. Number 10 final thoughts. As we wrap up, the most important message is clear. The 2026 deportation law is more than just a policy change. It's a wake-up call. The landscape of UK immigration is shifting, and while these changes aim to streamline enforcement, they also create real challenges for residents, visa holders, and families who have built their lives here. Ignorance is no longer an option. Preparation is your shield. One of the most overlooked realities is how small details can have big consequences. Expired visas, missed deadlines, incomplete documents, or minor legal issues can now trigger faster action. The law is designed to move quickly, leaving little margin for error. Being proactive isn't just wise, it's essential. Equally important is staying informed. Immigration rules will continue to evolve, and the future may bring even stricter measures or new categories of affected individuals. Regularly reviewing your status, understanding your rights, and consulting qualified immigration advisors are all steps that help you stay ahead of potential problems. Knowledge is power, and in 2026, it may literally protect your ability to stay in the UK. Finally, don't underestimate the emotional and practical aspects. Preparing for change isn't just about paperwork. It's about mental readiness, family planning, and financial security. The more prepared you are, the less vulnerable you become to unexpected enforcement actions. In short, the 2026 deportation law is not just legislation. It's a call to action. Taking it seriously today can save you stress, uncertainty, and potential hardships. The new 2026 deportation law is not just another headline. It's a game changer for thousands of people living in the UK. From long-term residents and visa holders to asylum seekers and individuals with minor legal issues, the changes affect far more than many realize. What makes this law particularly powerful is not just who it targets, but how fast it can act, leaving little room for error or delay. Understanding the law is the first step toward protection. Knowing your visa status, residency documents, and deadlines can make the difference between staying secure and facing unexpected enforcement. Even those who feel completely safe should take stock of their situation. Indefinite leave to remain is valuable, but it is not a guarantee against deportation. Citizenship provides a higher level of protection, and if you are eligible, applying sooner rather than later could prevent serious complications. Preparation is equally important. Organize your documents, keep digital and physical copies, and maintain accurate records of all communications with the Home Office. Consult licensed immigration advisors if you have doubts or past legal concerns. Staying informed is critical. The law is evolving, and relying on assumptions or outdated information could put you at risk. Finally, take care of the practical and emotional side. Understanding your rights, planning for contingencies, and staying proactive reduces stress and ensures you are ready for any situation. Knowledge is not just power. In this case, it is protection. The 2026 deportation law is strict, fast, and far-reaching, but it doesn't have to catch you off guard. By staying vigilant, informed, and prepared, you can protect yourself, your family, and your future in the UK. The key takeaway is simple. Don't wait for problems to find you. Act now to secure your position and peace of mind.